Under what circumstances can a court revoke a power of attorney in healthcare proxy? To find out, you have to read Matter of Goldfein versus Kohler, but it's 2 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is part of a special series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Matter of Goldfein versus Kohler. This is a First Department Appellate Division case from November 21st of 2023. And the citation for this case is 2023 New York Slip Opinion 05982. The issue in this case is when a guardianship judge can revoke a healthcare proxy and a power of attorney following a guardianship hearing. To understand and appreciate the background of this case, to get where the case fits in, you have to know just a little bit about healthcare proxies, powers of attorney, and guardianship cases. A healthcare proxy can be found in Public Health Law 2980 in that area of the law, the subsections before and after. The definition of a healthcare proxy is it's a written document delegating the authority to make healthcare decisions for the principal. So a principal executes a healthcare proxy and names an agent to make those decisions on behalf of the principal. Similarly, a power of attorney, which can be found in General Obligations Law 5-1501 and those subsections, is a written document by which a principal with capacity designates an agent to act on his or her behalf for non-medical purposes, to sign contracts, to litigate cases, to buy and sell things. This is what a power of attorney allows an agent to do. And a power of attorney is a fiduciary on behalf of the principal in that circumstance. And the last thing you have to know is what a guardianship is. Under Mental Hygiene Law, Article 81, a guardianship is when a court determines that a person has certain functional limitations, incapacities, and either has a necessity and either incapacity or agrees to the appointment of a guardian. And if there's a necessity and incapacity or necessity and an agreement for a guardian, then that person gets powers that help the ward, the incapacitated person or alleged incapacitated person, handle property management or personal needs. And you can see how that might conflict with a healthcare proxy and a power of attorney. If a guardian has personal needs powers to make decisions for the ward, that might be inconsistent with and contrary to the decisions that an agent under a healthcare proxy would make. The last thing you have to know is that a guardian can only be appointed when it is the least restrictive alternative that satisfies the needs of the alleged incapacitated person. That's part of the statute. So what are the facts in this case? The facts are that a person named Kohler, Kohler, Kohler lived in an apartment for years, which was falling into disrepair. It was unsanitary. It was not good. Kohler then executed years into this disrepair and sort of living in a poor situation. Kohler executed a healthcare proxy and a power of attorney naming a person named Egerud as her agent for both the healthcare proxy and the power of attorney. The apartment continued to be in disrepair, and the building staff refused to comply with Kohler's or Egerud's request to make necessary repairs. An application for an Article 81 guardianship was filed around March of 2022, and when the judge received that application, the judge issued a temporary restraining order suspending the healthcare proxy and the power of attorney while the guardianship case was proceeding. During the hearing, Kohler, this is the alleged incapacitated person, unequivocally expressed her wishes to have Egerud be her agent at the hearing. So she kind of reaffirmed that the person that she named as her agent on these 2 different documents, she still wanted that person to have the powers to exercise to protect Kohler. The court finished the hearing and found the AIP needed a guardian, was incapacitated, and then revoked the healthcare proxy and the power of attorney, appointing a guardian, a different person as guardian of personal needs and property management to care for Kohler. Egerud, the procedural history is Egerud then appealed that guardianship order, and it goes to the Appellate Division First Department, and that's what this case is. And the First Department Appellate Division basically helps clarify the issue of revocation of a healthcare proxy or power of attorney. And they say the court may only revoke a power of attorney or healthcare proxy if the court finds that the document was made while a person was incapacitated, or if the court determines that there has been a breach of fiduciary duty using those documents. So there's only two grounds to revoke at the end of a hearing those two advance directives: that they were executed while the person was incapacitated, or that there was a breach of fiduciary duty. And they say here, there's no indication, there was no evidence submitted that the documents were executed while Kohler lacked capacity. So put that to the side. The only issue here is whether there was a breach of fiduciary duty. And as to that, they say the evidence was insufficient in this case to establish it. First of all, the apartment was in bad repair for years before the advance directives were issued. And then when the court received it, when the court received the guardianship application, they suspended the TRO. They put a TRO or suspending the healthcare proxy and the power of attorney, which meant that Egerud had no authority at that point, once the suspension happened, to use that power of attorney or healthcare proxy to help better the situation for Kohler. And they say, based upon the evidence submitted in this case, on this particular set of hearing, on this particular set of facts, there was insufficient evidence to revoke the healthcare proxy and power of attorney. And since those two documents, those two advance directives, would address the needs of the AIP, of the alleged incapacitated person, then guardianship is no longer the least restrictive alternative. There's a lesser restrictive alternative, which is these advance directives. So because these two advance directives are reinstated by the appellate division, the guardianship is terminated. And that's the case of matter of Goldfein versus Kohler, which talks about the power and importance of advance directives. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.